Mayor John Amado Corpus, Jr., and Carlito Samonte, petitioners, vs. Hon Judge Ramon D. Pamular of Branch 33, Gamba, Nueva Ecija, MRS Priscilla Espinoza, and Nueva Ecija Provincial Public Prosecutor Floro Florendo, respondents. Decision. Leonin, J. An allegation of conspiracy to add a new accused without changing the prosecution's theory that the accused willfully shot the victim is merely a formal amendment. However, the rule provides that only formal amendments not prejudicial to the rights of the accused are allowed after plea. The test of whether an accused is prejudiced by an amendment is to determine whether a defense under the original information will still be available even after the amendment is made and if any evidence that an accused might have would remain applicable even in the amended information. This petition for certiorari under Rule 65 of the Rules of Court assails the February 26, 2009 order and warrant of arrest issued by Judge Ramon D. Pamular, Judge Pamular, of Branch 33, Regional Trial Court, Gamba, Nueva Ecija in Civil Case No. 2618G. The assailed order granted the prosecution's motion to amend the original information for murder filed against Carlito Samonte, to include Mayor Amado John Corpus. Corpus, as his co-accused in the crime charged. Furthermore, it directed the issuance of a warrant of arrest against Corpus. Angelito Espinosa, Angelito, was shot by Semonte at Corpus Street, Quiepo, Nueva Ecija on June 4, 2008, causing his death. Semonte was caught in flagrante delicto and thereafter was arrested. After the inquest proceedings, an information for murder dated June 5, 2008 was filed against him, thus. Information. Undersigned. Inquest. Prosecutor accuses Carlito Semonte y Lapitan of the crime of murder, committed as follows. That on or about the 4th day of June, 2008 at around 10:30 a.m. at Corpus St, Dist, in the municipality/city of Quiepo, province of Nueva Ecija, Philippines, and within the jurisdiction of this honorable court, the above-named accused, did then and there, with malice aforethought and with deliberate intent to take the life of Angelito Espinosa, willfully, unlawfully and feloniously, treacherously and taking advantage of superior strength attack the latter and shot with an unlicensed firearm, 1 Colt .45 cal pistol with SN 217,815, thereby inflicting upon him gunshot wounds, which directly caused the death of said Angelito Espinosa, to the damage and prejudice of his heirs. Contrary to law. Cabanatuan City for Gamba, Nueva Ecija, June 5, 2008. Upon arraignment, Semonte admitted the killing but pleaded self-defense. Trial on the merits ensued. The wife of the deceased, Mrs. Priscilla Alcantara Espinosa, Priscilla, filed a complaint affidavit captioned as reply affidavit dated September 8, 2008 after the prosecution presented its second witness. She also filed an unsworn but signed reply to the affidavit of witnesses before First Assistant Provincial Prosecutor and Officer in Charge Floro F. Florendo. Other affidavits of witnesses were also filed before the prosecutor's office, which included the following. A. Affidavit of Mr. John Diego, Vice Mayor of Quiepo, Nueva Ecija. B. Original affidavit and a supplemental affidavit of witness Alexander Lozano y Jacob, and C. Joint affidavit of Victoria A. Miraflex, Ma Flores Mina S. Saka Ianan, Ma Asuncion El Silao and Corazon Engertson. Based on the affidavit executed by Alexander Lozano, on June 30, 2008, Corpus was the one who instructed Semonte to kill Angelito. In response to Priscilla's reply affidavit, Corpus filed a rejoinder affidavit. He also filed a counter-affidavit against witness Lozano's affidavit. In its October 7, 2008 resolution, the Regional Trial Court dismissed Priscilla's complaint and the attached affidavits of witnesses. Priscilla filed a motion for reconsideration, which was opposed by Corpus. Florendo reconsidered and set aside the October 7, 2008 resolution. He also instructed Assistant Public Prosecutor Edwin S. Bonifacio, to conduct the review. Bonifacio was not able to comply with the directive to personally submit his resolution by January 22, 2009, prompting Florendo to order him to surrender the records of the case as the latter was taking over the resolution of the case based on the evidence presented by the parties. This order was released on January 23, 2009 and was received by Bonifacio on the same date. In his January 26, 2009 resolution, Florendo found probable cause to indict Corpus for Angelito's murder. He directed the filing of an amended information before the Regional Trial Court. The amended information provided information Undersigned prosecutor accuses Carlito Samonte y Lapitan and Amado Corpus, J.R.Y. Ramos of the crime of murder, committed as follows. That on or about the 4th day of June, 2008 at around 10:30 a.m. at Corpus St. Dist. In the municipality of Quiapo, province of Nueva Ecija, Philippines, sic, and within the jurisdiction of this honorable court the above named accused, conspiring and confederating together, did then, and there, with malice aforethought and with deliberate intent to take the life of Angelito Espinosa, willfully, unlawfully and feloniously, treacherously and taking advantage of superior strength attack the latter and shot with an unlicensed firearm, 1 Colt .45 cal pistol with SN 217,815, thereby inflicting upon him gunshot wounds, which directly caused the death of said Angelito Espinosa, to the damage and prejudice of his heirs. Contrary to law. Cabanatuan City for Gamba, Nueva Ecija, January 26, 2009. Emphasis supplied. Despite Florendo taking over the case, Bonifacio still issued a review resolution dated January 26, 2009, where he reinstated the Regional Trial Court October 7, 2008. Resolution and affirmed the dismissal of the murder complaint against Corpus. The dispositive portion of his resolution provided. In view of the foregoing and probable cause, the resolution of Assistant Provincial Prosecutor Edison V. Raffanin, dated October 7, 2008, being in accord with the facts obtaining in this case and with established rules, procedures, and jurisprudence, is reinstated. The criminal complaint for murder against Respondent Mayor Amado John Corpus is dismissed. Emphasis in the original. Meanwhile, Florendo filed an undated motion to amend information, praying for the admission of the amended information. Corpus and Samonte opposed this motion by filing a joint urgent manifestation/opposition dated February 2, 2009. The prosecution filed a motion for reconsideration. Samonte and Corpus opposed this through a vehement opposition and omnibus motion dated February 4, 2009. They averred that Judge Pamular's action was premature considering that the motion to amend information has yet to be scheduled for hearing. Moreover, Samonte was already arraigned. Samonte and Corpus also claimed that the issuance of a warrant of arrest should be suspended because the latter intended to appeal through a petition for review before the Department of Justice. Samonte and Corpus jointly filed a petition for review dated February 9, 2009 before the Department of Justice. They also filed a manifestation and motion dated February 9, 2009 with the Regional Trial Court, asking it to desist from acting further on the amended information in view of the petition for review filed with the Department of Justice. However, despite the manifestation, Judge Pamular of Branch 33, Regional Trial Court, Gamba, Nueva Ecija issued the assailed February 26, 2009 order, which granted the motion to amend the information and to admit the attached amended information. The assailed order also directed, among others, the issuance of a warrant of arrest against Corpus. The dispositive portion of the order read: Wherefore premises considered this court after personally examining the amended information and its supporting documents finds probable cause and hereby orders to 1. Grant the motion to amend the information, 2. Admit the attached amended information, 3. Issue the warrant of arrest for the immediate apprehension of Respondent Movimento Corpus, Jr., and 4. Deny the motion to defer/suspend arraignment and further proceedings of this case. So ordered. Hence, a direct recourse before this court, through a petition for certiorari under Rule 65 with a prayer for an immediate issuance of a temporary restraining order, was filed by Corpus and Samonte on March 3, 2009. This petition seeks to enjoin Judge Pamular from enforcing the February 26, 2009 order and the warrant of arrest issued pursuant to the order, and from conducting further proceedings in the murder case. Through its March 9, 2009 resolution, this court required respondents to comment on the petition. It also granted petitioners' prayer for a temporary restraining order. Judge Pamular, Florendo, Priscilla, and all other persons acting on the assailed Regional Trial Court February 26, 2009 order were enjoined from implementing it and the warrant of arrest issued pursuant to it. Priscilla filed her comment on April 3, 2009. She cites Omenal v. Castillo, which provided that in filing a petition for certiorari under Rule 65, Section 1 there should be no appeal nor any plain, speedy, and adequate remedy in the ordinary course of law available. Considering that there is still a remedy available for the accused apart from filing a petition, the petition shall fail. She claims that petitioners should have first filed a motion for reconsideration with the Regional Trial Court before resorting to a petition for certiorari before this court. She insists that the Regional Trial Court is correct in granting the motion to admit the amended information because it has no effect on Samonta's case and reasoned that first, because there would only be an addition of another accused with prior authority from the Honorable Provincial Prosecutor. Second, the amendment will not cause any prejudice to the rights of the accused and more importantly, that is what is provided for by the rules. She claims that the alleged lack of determination of probable cause before the issuance of a warrant has no basis since petitioners failed to present evidence or facts that would prove their claim. Judge Pamular filed his comment on April 8, 2009. He asserts that he made a careful perusal of the case records in issuing the assailed order. His independent judgment on the existence of probable cause was derived from his reading and evaluation of pertinent documents and evidence. He states that he had set the case for hearing on February 13, 2009, when both parties were heard and given the opportunity to argue. He also added, "Yes, indeed, while the undersigned could rely on the findings of the Honorable Provincial Prosecutor, I am nevertheless not bound thereby. The termination by the latter of the existence of probable cause is for a purpose different from that which is to be made by the herein respondent judge. I have no cogent reason to question the validity of the findings of the Honorable Provincial Prosecutor. I have much respect for the latter. Thus, after giving due course to the arguments of parties and their respective counsels, I was fully convinced in good faith that, indeed, there was a reasonable ground to believe in the existence of probable cause for the immediate apprehension and prosecution of Mayor Amado John Corpus, Jr. Hence, the issuance of the assailed controversial order. On July 22, 2009, Priscilla filed a manifestation before this court. She asserts that this present petition questioning the alleged impropriety of the admission of the amended information as well as the issuance of a warrant of arrest against Mayor Amado Corpus, Jr. has no more legal legs to stand on. She claims that Florinda's January 26, 2009 resolution was upheld by the Department of Justice in its June 26, 2009 resolution, the FIO of which read, "Wherefore, premises considered, the petition for review is hereby dismissed. Accordingly, the officer in charge Provincial Prosecutor of Nueva Ecija is directed to file the appropriate information against the respondent Mayor Amado Corpus, Jr., and to report the action taken thereon within 10 days from receipt hereof. So ordered, emphasis supplied." Priscilla asserts further that the issue regarding the suspension of proceedings pending resolution by the Department of Justice can now be considered moot and academic. On July 24, 2009, petitioners filed a counter-manifestation. They claim that respondent Priscilla's prayer for the lifting of the temporary restraining order is premature, thus Priscilla should have been more candid. She should have informed the Honorable Court that a motion for reconsideration with the Department of Justice was filed by the herein petitioner, and is still pending resolution. And in the event said motion for reconsideration is denied, and as a part of petitioner/accused right to due process of law, it being clearly provided by the rules, he would elevate said resolution to the Court of Appeals on certiorari, and, certainly, the aggrieved party would bring the matter before this Honorable Court, during which interregnum the appealed resolution of the Provincial Prosecutor would not have yet attained finality, which is what jurisprudence underscores. Before the respondent court should have proceeded with the amended information. Emphasis supplied, citations omitted. They further claim that lifting the temporary restraining order would be a relief, too harsh and preposterous, since Corpus would be immediately imprisoned and constrained to face trial due to a flawed amended information. In case this court resolves to quash the amended information and nullify the warrant, Corpus will have already suffered grave and irreparable injury, as he would not be able to discharge his constitutional mandate/duty to his constituents as their duly elected mayor. As to Semonte, he will be allegedly forced to face another set of defense against the theory of conspiracy in the amended information which, as we have heretofore stated, after his arraignment and trial halfway, could no longer be proper. On August 6, 2009, the Office of the Solicitor General filed its comment. It claims that petitioners should have made a distinction on the propriety of respondent judge's acts in granting the admission of the amended information and in ordering the issuance of a warrant. It posits that these acts are at par with the court's acquisition of jurisdiction over the subject matter and the person of the accused. These acts have nothing to do with the suspension of arraignment provided for under Rule 116, Section 11 of the Revised Rules of Criminal Procedure, which ordinarily happens after a trial court has acquired jurisdiction. The Office of the Solicitor General also adds that the insertion of the phrase, conspiring and confederating together, in the amended information will not affect Semonte's substantial rights. Thus, the original charge against Semonte of murder and his deliberate manner of shooting Angelita remain unaltered. Even if one or all of the elements of the crime of murder as alleged in the original information filed against petitioner Semonte is not proven, the addition of conspiracy in the amended information, if duly proven, would not in any way result in his conviction because conspiracy is not an essential or qualifying element of the crime of murder. The Office of the Solicitor General avers that respondent judge was well acquainted with the legal and factual circumstances behind the filing of the original information against Semonte. The amended information merely added Corpus as a co-conspirator. Thus, before respondent judge issued the assailed order, a prior hearing was held on February 13, 2009, when all the parties were heard. The Office of the Solicitor General also asserts that while respondent judge committed error when he denied petitioner's motion to suspend proceedings, what the law only requires under Rule 116, Section 11 is a maximum of 60-day suspension of the arraignment. In this case, the 60-day period had already lapsed, rendering the issue raised by petitioners moot. Hence, there is no longer any hindrance for respondent judge to continue with Corpus arraignment. Petitioners filed their reply on August 7, 2009. They claim that respondent judge should have suspended action on the issuance of a warrant considering the pendency of their petition for review before the Department of Justice. They cite Ledesma v. Court of Appeals, which stated, where the Secretary of Justice exercises his power of review only after an information has been filed, trial courts should defer or suspend arraignment and further proceedings until the appeal is resolved. Such deferment or suspension, however, does not signify that the trial court is ipso facto bound by the resolution of the Secretary of Justice. Jurisdiction, once acquired by the trial court, is not lost despite a resolution by the Secretary of Justice to withdraw the information or to dismiss the case. Petitioners also cite the dispositive portion of Tolentino v. Bonifacio, which directed the respondent judge in that case to desist from proceeding with the trial until after the Department of Justice would have finally resolved a pending petition for review. Thus, while we have noted from the expediente that the petitioner has utilized dilatory tactics to bring the case against her to trial, still she is entitled to the remedy she seeks. The respondent judge should not be more anxious than the prosecution in expediting the disposition of the case absent any indication of collusion between it and the defense. The Ministry of Justice should not be deprived of its power to review the action of the city fiscal by a precipitate trial of the case. Wherefore, the petition is granted. The respondent judge is hereby ordered not to proceed with the trial of the above-numbered criminal case until after the Ministry of Justice has resolved the petition for review filed by Mila P. Tolentino. No costs, emphasis supplied. Petitioners claim that due to the theory of conspiracy in the amended information, Semonte will have an additional burden of setting up a new defense, particularly on any acts of his co-accused, since the act of one is the act of all. Petitioners also claim that respondent judge failed to comply with the mandate of making a prior determination of probable cause before issuing the warrant. They insist that this mandate is never excused nor dispensed with by the respondent judge's self-serving narration of the law, not the required facts, stated in his assailed order. On the issue of whether the arraignment of corpus may proceed despite the lapse of the 60-day maximum period of suspension under Rule 116, Section 11, c. Petitioners aver that W-hat jurisprudence underscores is not the lapse of the 60-day period, but the issue of finality of the decision on appeal. The matter should not only cover the suspension of arraignment but for respondent judge to defer from further proceedings on the amended information pending the final resolution of the Department of Justice. This court, through its August 26, 2009 resolution, required the parties to submit their respective memoranda. Petitioners filed their memorandum on October 15, 2009. In their memorandum, they attached the Department of Justice September 8, 2009 resolution which granted their motion for reconsideration, thus. Wherefore, the motion for reconsideration of the respondent is hereby granted. Accordingly, the resolution promulgated on June 26, 2009, Resolution Number 473, is hereby reversed and set aside. The Provincial Prosecutor of Nueva Ecija is hereby directed to cause the withdrawal of the information for murder against the respondent, if one has been filed in court, and to report the action taken thereon within 10 days from receipt hereof. So ordered, emphasis in the original. Petitioners assert that Rule 116, Section 11, c. of the Revised Rules of Criminal Procedure provides that upon motion by the proper party, the arraignment shall be suspended. Rule 116 Arraignment and Plea. Section 11. Suspension of arraignment. Upon motion by the proper party, the arraignment shall be suspended in the following cases. C. A petition for review of the resolution of the prosecutor is pending at either the Department of Justice or the Office of President, provided that the period of suspension shall not exceed 60 days counted from the filing of the petition with the reviewing office. Petitioners add that respondent judge should have refrained from issuing the assailed warrant of arrest because he was aware of the fact that the amended information was a result of the flip-flopping stand of the public prosecutor from his original stand. Thus, they claim that the motive behind the filing of the amended information that included Corpus as an additional accused is political. They aver that respondent judge failed to personally make his independent findings of probable cause that will justify the issuance of the warrant. They insist that the February 26, 2009 order only consists of three short sentences, which merely pointed out a certain legal provision, instead of facts, that would supposedly justify the issuance of the warrant of arrest, thus. Elementary is the rule that the existence of probable cause is indispensable in the filing of the complaint or information and in the issuance of warrant of arrest. The legion of jurisprudence has defined probable cause to be concerned with probability, not absolute or even moral certainty. The prosecution need not present at this stage proof beyond reasonable doubt. The standards of judgment are those of a reasonably prudent man and not the exacting calibrations of a judge after a full-blown trial. No law or rule states that probable cause requires a specific kind of evidence. It is determined in the light of conditions obtaining in a given situation. Petitioners also cite Rule 110, Section 14 of the Revised Rules of Criminal Procedure, which prohibits substantial amendment of information that is prejudicial to the rights of the accused after his or her arraignment, thus. Rule 110 Prosecution of Offenses. Section 14. Amendment or substitution. A complaint or information may be amended, in form or in substance, without leave of court, at any time before the accused enters his plea. After the plea and during the trial, a formal amendment may only be made with leave of court and when it can be done without causing prejudice to the rights of the accused, emphasis in the original. They cite People v. Montenegro, which provided that an allegation of conspiracy that was not previously included in the original information constitutes a substantial amendment. The allegation of conspiracy among all the private respondents accused, which was not previously included in the original information, is likewise a substantial amendment saddling the respondents with the need of a new defense in order to meet a different situation in the trial court. In People v. Zulueta, it was held that surely the preparations made by herein accused to face the original charges will have to be radically modified to meet the new situation. For undoubtedly the allegation of conspiracy enables the prosecution to attribute and ascribe to the accused Zuluatal the act's knowledge, admission Sandiv and omission Safi's co-conspirator Angel Lan as in furtherance of the conspiracy. The amendment thereby widens the battlefront to allow the use by the prosecution of newly discovered weapons, to the evident discomfiture of the opposite camp. Thus it would seem inequitable to sanction the tactical movement at this stage of the controversy, bearing in mind that the accused is only guaranteed 2 days, preparation for trial. Needless to emphasize, as in criminal cases, the liberty, even the life, of the accused is at stake. It is always wise and proper that he be fully apprised of the charges, to avoid any possible surprise that may lead to injustice. The prosecution has too many facilities to covet the added advantage of meeting unprepared adversaries. To allow at this stage the proposed amendment alleging conspiracy among all the accused, will make all of the latter liable not only for their own individual transgressions or acts, also for the acts of their co-conspirators. Emphasis in the original. The Office of the Solicitor General filed its memorandum on October 16, 2009, which merely reiterated the arguments and discussions in its comment to the petition. Similarly, Respondent Priscilla's memorandum adopted the arguments presented by the Office of the Solicitor General in its comment and memorandum. On March 19, 2014, Priscilla filed a manifestation which provides that on October 30, 2013, Samonte executed an affidavit stating that Corpus ordered him to kill Angelito. Samonte's affidavit provided on April 14, 2014, this court received Priscilla's letter dated April 11, 2014 addressed to the Chief Justice of the Supreme Court, asking for assistance in the resumption of trial in view of Samonte's affidavit. The issues for this court's resolution are as follows. First, whether or not Respondent Judge Ramon Pamular committed grave abuse of discretion amounting to lack or excess of jurisdiction when he conducted further proceedings on the amended information and consequently issued a warrant of arrest against Petitioner Amado Corpus, Jr. Despite the pendency of his and Petitioner Carlito Samonte's petition for review before the Department of Justice. Second, whether or not the arraignment of Petitioner Amado Corpus, JR may proceed after the lapse of the maximum 60-day period suspension provided for under Rule 116, Section 11, c, of the Revised Rules of Criminal Procedure. Third, whether or not Respondent Judge Ramon Pamular committed grave abuse of discretion amounting to lack or excess of jurisdiction when he allegedly admitted the amended information in clear defiance of law and jurisprudence, which proscribes substantial amendment of information prejudicial to the right of the accused, and finally, whether or not Respondent Judge Ramon Pamular has personally determined, through evaluation of the prosecutor's report and supporting documents, the existence of probable cause for the issuance of a warrant of arrest against Petitioner Amado Corpus, Jr. The petition lacks merit. Before this court delves on the substantive issues in this case, it first rules on the procedural matter involved. Respondent Priscilla claims that petitioners should have first filed a motion for reconsideration with the regional trial court before resorting to this petition. Failure to do so renders it dismissible. This issue was not addressed by petitioners in their reply or memorandum. However, petitioners justified their direct recourse before this court insisting that their case is anchored on pure questions of law and impressed with public interest. Thus, they claim that regardless of the rule on hierarchy of courts, their filing of a petition is not a matter of choice but even mandatory. Rule 65, Section 1 of the Revised Rules of Civil Procedure provides. Section 1. Petition for certiorari. When any tribunal, board, or officer exercising judicial or quasi-judicial functions has acted without or in excess of its or his jurisdiction, or with grave abuse of discretion amounting to lack or excess of jurisdiction, and there is no appeal, or any plain, speedy, and adequate remedy in the ordinary course of law. A person aggrieved thereby may file a verified petition in the proper court, alleging the facts with certainty and praying that judgment be rendered annulling or modifying the proceedings of such tribunal, board, or officer, and granting such incidental reliefs as law and justice may require. Emphasis supplied. Rivera v. Espiritu enumerated the essential requisites for a petition for certiorari under Rule 65. 1. He writ is directed against a tribunal, a board, or an officer exercising judicial or quasi-judicial functions. 2. Such tribunal, board, or officer has acted without or in excess of jurisdiction, or with grave abuse of discretion amounting to lack or excess of jurisdiction, and 3. There is no appeal or any plain, speedy, and adequate remedy in the ordinary course of law. Emphasis supplied, citation omitted. The plain and adequate remedy pertained to by the rules is a motion for reconsideration of the assailed order or decision. Certiorari, therefore, is not a shield from the adverse consequences of an omission to file the required motion for reconsideration. It is settled that a motion for reconsideration is a condition sine qua non for the filing of a petition for certiorari. This enables the court to correct any actual or perceived error through a re-examination of the legal and factual circumstances of the case. To dispense with this condition, there must be a concrete, compelling, and valid reason. However, the following exceptions apply. A. Where the order is a patent of nullity, as where the court a quo has no jurisdiction. B. Where the questions raised in the certiorari proceedings have been duly raised and passed upon by the lower court, or are the same as those raised and passed upon in the lower court. C. Where there is an urgent necessity for the resolution of the question and any further delay would prejudice the interests of the government or of the petitioner or the subject matter of the action is perishable. D. Where under the circumstances a motion for reconsideration would be useless. E. Where petitioner was deprived of due process and there is extreme urgency for relief. F. Where, in a criminal case, relief from an order of arrest is urgent and the granting of such relief by the trial court is improbable. G. Where the proceedings in the lower court are a nullity for lack of due process. H. Were ex parte or in which the petitioner had no opportunity to object, and I. Where the issue raised is one purely of law or where public interest is involved. Nothing in the records shows that petitioners filed a motion for reconsideration with the regional trial court. Apart from bare conclusion, petitioners failed to present any plausible reason why they failed to file a motion for reconsideration before filing a petition before this court. While this issue was raised by respondent Priscilla in her comment, this was not sufficiently addressed by petitioners either in their reply or memorandum. It must be stressed that the filing of a motion for reconsideration, as well as filing it on time, is not a mere procedural technicality. These are jurisdictional and mandatory requirements which must be strictly complied with. Therefore, petitioners' failure to file a motion for reconsideration with the regional trial court before filing this petition is fatal. 2. 2 kinds of determination of probable cause exist, executive and judicial. These two kinds of determination of probable cause were distinguished in People v. Castillo. Thus, there are two kinds of determination of probable cause, executive and judicial. The executive determination of probable cause is one made during preliminary investigation. It is a function that properly pertains to the public prosecutor, who is given a broad discretion to determine whether probable cause exists and to charge those whom he believes to have committed the crime as defined by law and thus should be held for trial. Otherwise stated, such official has the quasi-judicial authority to determine whether or not a criminal case must be filed in court. Whether or not that function has been correctly discharged by the public prosecutor, i.e., whether or not he has made a correct ascertainment of the existence of probable cause in a case, is a matter that the trial court itself does not and may not be compelled to pass upon. The judicial determination of probable cause, on the other hand, is one made by the judge to ascertain whether a warrant of arrest should be issued against the accused. The judge must satisfy himself that based on the evidence submitted, there is necessity for placing the accused under custody in order not to frustrate the ends of justice. If the judge finds no probable cause, the judge cannot be forced to issue the arrest warrant. The public prosecutor exercises a wide latitude of discretion in determining whether a criminal case should be filed in court, and that courts must respect the exercise of such discretion when the information filed against the person charged is valid on its face, and that no manifest error or grave abuse of discretion can be imputed to the public prosecutor, emphasis supplied, citations omitted. Thus, courts do not meddle with the prosecutor's conduct of a preliminary investigation because it is exclusively within the prosecutor's discretion. However, once the information is already filed in court, the court has acquired jurisdiction of the case. Any motion to dismiss or determination of the guilt or innocence of the accused is within its discretion. Crespo v. Mogul. Provided the filing of a complaint or information in court initiates a criminal action, the court thereby acquires jurisdiction over the case, which is the authority to hear and determine the case. When after the filing of the complaint or information a warrant for the arrest of the accused is issued by the trial court and the accused either voluntarily submitted himself to the court or was duly arrested, the court thereby acquired jurisdiction over the person of the accused. The preliminary investigation conducted by the fiscal for the purpose of determining whether a prima facie case exists warranting the prosecution of the accused is terminated upon the filing of the information in the proper court. In turn, as above stated, the filing of said information sets in motion the criminal action against the accused in court. Should the fiscal find it proper to conduct a re-investigation of the case, at such stage, the permission of the court must be secured. After such re-investigation, the finding and recommendations of the fiscal should be submitted to the court for appropriate action. While it is true that the fiscal has the quasi-judicial discretion to determine whether or not a criminal case should be filed in court or not, once the case had already been brought to court, whatever disposition the fiscal may feel should be proper in the case thereafter should be addressed for the consideration of the court. The only qualification is that the action of the court must not impair the substantial rights of the accused or the right of the people to due process of law. Whether the accused had been arraigned or not, and whether it was due to a re-investigation by the fiscal or a review by the Secretary of Justice whereby a motion to dismiss was submitted to the court in the exercise of its discretion may grant the motion or deny it and require that the trial on the merits proceed for the proper determination of the case. However, one may ask, if the trial court refuses to grant the motion to dismiss filed by the fiscal upon the directive of the Secretary of Justice, will there not be a vacuum in the prosecution? A state prosecutor to handle the case cannot possibly be designated by the Secretary of Justice, who does not believe that there is a basis for prosecution, nor can the fiscal be expected to handle the prosecution of the case, thereby defying the superior order of the Secretary of Justice. The answer is simple. The role of the fiscal or prosecutor, as we all know, is to see that justice is done and not necessarily to secure the conviction of the person accused before the courts. Thus, in spite of his opinion to the contrary, it is the duty of the fiscal to proceed with the presentation of evidence of the prosecution to the court to enable the court to arrive at its own independent judgment as to whether the accused should be convicted or acquitted. The fiscal should not shirk from the responsibility of appearing for the people of the Philippines even under such circumstances, much less should he abandon the prosecution of the case, leaving it to the hands of a private prosecutor, for then the entire proceedings will be null and void. The least that the fiscal should do is to continue to appear for the prosecution, although he may turn over the presentation of the evidence to the private prosecutor, but still under his direction and control. The rule therefore in this jurisdiction is that once a complaint or information is filed in court, any disposition of the case as to its dismissal or the conviction or acquittal of the accused rests in the sound discretion of the court. Although the fiscal retains the direction and control of the prosecution of criminal cases even while the case is already in court, he cannot impose his opinion on the trial court. The court is the best and sole judge on what to do with the case before it. The determination of the case is within its exclusive jurisdiction and competence. A motion to dismiss the case filed by the fiscal should be addressed to the court, who has the option to grant or deny the same. It does not matter if this is done before or after the arraignment of the accused, or that the motion was filed after a re-investigation or upon instructions of the Secretary of Justice, who reviewed the records of the investigation, emphasis supplied, citations omitted. Hence, when a regional trial court has already determined that probable cause exists for the issuance of a warrant of arrest, like in this case, jurisdiction is already with the regional trial court. Therefore, it can proceed in conducting further proceedings on the amended information and on the issuance of a warrant despite the pendency of a petition for review before the Department of Justice. 3.a. Petitioners insist that respondent judge should have deferred from conducting further proceedings on the amended information and on the issuance of a warrant, considering the pendency of their petition for review before the Department of Justice. They cite Rule 116, Section 11, c, of the Revised Rules of Criminal Procedure, which provides Rule 116 Arraignment and Plea. Section 11. Suspension of arraignment upon motion by the proper party. The arraignment shall be suspended in the following cases. c. A petition for review of the resolution of the prosecutor is pending at either the Department of Justice, or the Office of the President, provided that the period of suspension shall not exceed 60 days counted from the filing of the petition with the reviewing office. Emphasis supplied. Rule 116, Section 11 of the Revised Rules of Criminal Procedure pertains to a suspension of an arraignment in case of a pending petition for review before the Department of Justice. It does not suspend the execution of a warrant of arrest for the purpose of acquiring jurisdiction over the person of an accused. In the assailed February 26, 2009 order, Judge Pamular denied Corpus' motion to defer or suspend arraignment and further proceedings. Petitioners claim that he should have suspended action on the issuance of a warrant considering the pendency of their petition for review before the Department of Justice, citing Ledesma v. Court of Appeal San Tolentino v. Bonifacio as their basis. Furthermore, they also assert that the assailed order defies Rule 116, Section 11 of the Revised Rules of Criminal Procedure. Rule 116, Section 11 of the Revised Rules of Criminal Procedure provides for the grounds for suspension of arraignment. Upon motion by the proper party, the arraignment shall be suspended in case of a pending petition for review of the prosecutor's resolution filed before the Department of Justice. Petitioners filed a manifestation in motion dated February 9, 2009 before the Regional Trial Court, informing it about their pending petition for review of the prosecutor's January 26, 2009 resolution before the main issue in Ledesma was whether the respondent judge in that case erred in denying the motion to withdraw information and the consequent motion for reconsideration. This court held that the act of the judge was erroneous since he failed to give his reasons for denying the